was a bill to Johnson's law office from the public defender. Is that
Anna Johnson.
okay? So we're now paying. I thought we gave money to the public defenders and they don't funnel it out. It goes straight from us.
No. You're thinking of.
So that's probably for the guardianship.
Yeah.
She does the. She's the guardian ad litem and guardianship and service.
Yeah. And she, instead of bringing them one by one, she waits till she has.
Not really.
I understand.
I don't know why it's classified as public defender. Maybe that's confusing because she's really not.
No, it says
Just public
guardian
defender.
on
On the bill, the transfer.
That's how it's probably classified, but she's like a.
Yeah, that's how Michelle was titled. She probably didn't know.
Okay. Rick is going to be on Zoom, I think. I've not heard. Dwayne's going to be just a minute late. I've not heard anything from David.
Good morning. It's 9 o'clock. I'd like to call this meeting to order of the Scott County Fiscal Court. This is our normal work business meeting for the 8th of September. Appreciate everyone being here. If you would join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. I'd like to ask Ms. Hamilton to call the roll, please.
Mr. Hostetler. Mr. Jones.
Here.
Mr. Wallace.
Here.
Mr. Corman.
Present.
Mr. Ellison. Mr. Pratt.
Here.
Mr. Livingston. Mr. Culbertson.
Here.
Judge Covington.
Present. Thank you, Ms. Hamilton. First item on our agenda is to consider the minutes from our previous meeting. Any questions or comments related to those minutes as presented?
Motion to approve.
We have a motion from Mr. Corman.
Second.
A second from Mr. Jones. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Number 5, transfers. Questions, comments?
Motion for approval.
Motion from Mr. Wallace.
Second.
Second from Mr. Corman. Any other questions? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Bills and hand checks. Jail general was $300,000. Clerk fees. Well, we need to. I'm sorry. I'm getting. Yeah, they just submitted those. So, anyone want to have any questions about that bills and hand checks there? Would there be a motion to approve that? Motion from Mr. Jones, second from Mr. Pratt. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Let the record reflect that Rebecca Johnson, our county clerk, submitted fees in the amount of $235,246.50. Also, let the record reflect that Magistrate Ryan Pratt completed his training unit. Mr. Pratt, usually we ask magistrates to comment on what was the most, profound moment of that training. Could you share anything?
Oh, I would love to. During the training, Rob and I were sitting in in Louisville, and we found out, Michelle Ray was in there with us, that the treasurer works at the behest of the fiscal court and not of the county judge executive. So everybody should know that.
So maybe I should have not asked you that question. No,
I'm just kidding.
No, those always pick up a few things that help us along the way, and I'm glad you were able to knock that out. We all are glad when we knock those out. Sheriff's Office report, tax settlement. Do you have that document? And usually you read it, Cam, so I'll let you read that.
All right, Tony Hampton, Scott County Sheriff, 2022 tax year settlement, Scott County Fiscal Court. Original certification, $3,582,160.99. Discounts, $65,103.99. Penalties, $7,222.24. Exonerations or increases, $24.30. Certificate of delinquent real estate, $25,280.61. Certificate of delinquent tangible, $847.62. Current year additional bills, $9,964.54. Real tangible commissions, $148,817.61. Prior year additional bills, $5,853. Prior year additional penalties, 0. Prior year additional discount, $117.06. Prior year additional commissions, $243.78. Exoneration decreases, $6,548.94. Current year refunds, $668.39. Prior year refunds, $4,050.72. So real tangible due district is $3,353,546.35. Amount previously paid was $3,353,645.39. So net amount owed is $99.04. Franchise receipt total is $169,576.81. Franchise discounts, $306.97. Franchise carried over 2023, $3,885.53. Commissions, $6,044.39. Franchise due district, $159,339.92. Amount previously paid was $158,353.85. Net amount due is $986.07. So the total balance owed or due is $887.03.
Questions or comments? And we need to vote to accept that settlement statement. And Sheriff Hampton, would you like to make any comment?
Put me on the payment plan.
Any questions or comments? Motion from Mr. Jones to accept. Second from Mr. Corman. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. Let the record reflect that Mr. Hostetler has joined us via Zoom. Mr. Hostetler, good morning. Next item, number 9, ordinance 2309, second reading, reapportionment. Any questions or comments before I ask Cam to read that summary?
Okay. All right, ordinance number 2309, an ordinance establishing the updated geographic boundaries for magisterial districts in Scott County. Summary. 1, provides that pursuant to KRS 67.045, which sets out the legal process requiring the county magisterial boundaries be redrawn based upon the population figures resulting from each decennial census, the fiscal court has appointed 3 citizen members to a magisterial reapportionment commission with the county clerk serving as a non-voting member, which has produced a written report establishing the estimated population of each magisterial district and its recommendation as to the new geographic boundaries of each district, and filed that report with the Scott County Clerk and each magistrate on July 20th, 2023. 2, adopts the recommendations of the Magisterial Reapportionment Commission with the exception of modifications to District 3 and District 4 as amended by the Scott County Fiscal Court, and provides a written description of the precinct boundaries and locations. 3, directs that all precinct boundaries and locations shall be set by the Scott County Clerk's Office and be recorded for public notice and access purposes. 4, takes effect on November the 8th, 2023. The full text of this ordinance is available for examination at the office of the Scott Fiscal Court Clerk, 101 East Main Street, Georgetown, Kentucky, 40324. introduced and publicly read the first time August 24th, 2023, publicly read the second time September 8th, 2023.
Questions or comments? Would there be a motion?
Motion.
Motion from Mr. Jones, second from Mr. Pratt. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed?
Aye.
So let the record reflect that we had nays from Rick Hostetler and Kelly Corman. Motion passes. Next, ordinance 2310, first reading, RV campgrounds, text amendment. We have two drafts that's been shared. We've had presentation last week. We had an email that was shared yesterday that had just a long list of examples of where the private system known as Fuji Clean is being used across the United States. And let the record reflect that Mr. Livingston has joined us as well. So before we move any forward, is there any questions or comments related, and what would be the pleasure of the court in regards to this consideration of this first reading? And then we'll certainly allow any member of our audience to address the court as well before we take up any matter.
Judge, I want to pass out a map, and I have been involved. Can you pass it down, Stacy? Thank you. I've been involved with city and county government for a long time, and after talking with GMWSS, I want to point out a few things that's on this map so that we're aware of this. The areas in the area in the blue is basically the city limits of Georgetown, which all has sewer access. But if you look at the areas in the pink, okay, things that going north on 25 up to the city of Sadieville, Mallard Point, Harbor Village. If you look at the interstate, you've got the rest areas, the city of Stamping Ground. We have US 25 to the trailer park. All those areas are serviced by GMWSS sewer. Those are high density areas where the council, the court have felt like it was the appropriate thing to run sewer to those places to address any type of sanitary issues. Now the areas highlighted in the yellow are the ones that are on private sewer, which is one time it was Longview and Del Plain Disposal. Now it's under Bluegrass Water, I believe is what it's called. And I wanted to show that map to everybody to look at all of the areas that have been outside of the city limits and high density areas that the council and the court have felt that it was important enough to spend millions of dollars, and that's millions of dollars running either to the city of Sadieville, $500,000 to go to the city of Stamping Ground, controlled by GMWSS. We have sewer out at Great Crossings Park. We have sewer at Brookings Park, which are outside the city limits. And the courts and the council in the past have felt like this was an important enough issue when we have a large population of people in a small area that sewer should be provided. I think that's where we're at today. This has no reflection upon Bluegrass RV and their development. It really is, does this court want to require that we have municipal sewer to service these high density areas in our county? To me, it's that simple. Do we do that or do we not? And when you look at other systems, you're leaving it up completely to the owners of those systems. And you are dependent completely on them to maintain that. And when you require sewer, you are relying on, whether it's Kentucky American or Georgetown Water, that's something that is not required on the individual developer to maintain those sewer systems. And that's why I'm passionate about this, because I've seen the tax dollars that's been spent over the years in these different areas. And this has all been confirmed by GMWSS in the areas that they serve outside the city limits. So I just wanted to show that map, and that's why I feel so strongly that I don't want to have to spend tax dollars in the future, like we've had to do in the past, on these high-density areas that we have lots of sewer users, or I'm sorry, users in a small area. So that's kind of where I'm at. It's either in our county, do we want to require these areas to have sewer and second entrances, or is there something else?
Can I?
David Livingston.
So this is a path I was going down last time. And thank you for doing this, because I've never seen it put down on paper. So are you essentially saying you're in favor of requiring the ability for sewer tap on, not a package plant? And I'm going to call it that. You can call it whatever you want to, but that's the words I'm going to use since I'm not into that type of industry. My argument, part of my argument last week was technology goes away and technology changes. And the problem is not the group that is in front of planning and zoning or fiscal court. It's the group 20 years from now that may own it. The trailer park 40 years ago was a different situation than it is today. And now the city and the county, and I think the holding company that owns the trailer park, how much was spent to run that sewer line up there?
$23 million.
$23 million. We will never recover that money. And that's taxpayer dollars, and that's ratepayers. So I don't disagree with you at all, because I look at this and what it's going to be 10, 15, 20 years from now, not what does it look like today. My example last week was the farm implement dealership on 25. My concern at the time wasn't the developer, the development. My concern was if that changes, and it's unfortunate that the planning and zoning attorney doesn't spell it out as to what that zone change actually meant, but that place could become a car dealership down the road. And it's not the intent of what you were doing when you voted on it, it's the outcome of what happens when you vote on it. So we can intend to do the best thing for the county and to do the best thing for development, but what does the outcome happen in 20 years from now? Because I'm not going to be sitting here, and I would venture to say that none of us will be sitting here.
Ryan Pratt.
Do you think, Chad, do you think this is different, though, than, like, I don't disagree with you, but my thought process goes to, I think this is a little bit different than, like, a homestead, because we ultimately could shut this down and make everybody leave. Like, people aren't living here. This isn't the trailer park or a subdivision, right? Like, we could, the ordinance that, the way I read it, we can shut it down, or the health department can shut it down. These people could leave. So it's, to me, it's two different things. Like, if this was a subdivision, like, I'm with you more. But, like, I struggle with that, because these people, we can shut it down, they can leave.
Well,
So, if I may, failure of the owner to maintain the private sewer system in good operation and free of violations from the local health department and/or state cabinet for health and family services shall be grounds for closure of the campground until the private sewer system is certified to be operating in compliance. Operator must notify the local health department immediately upon discovery of a failure.
Judge, that's probably some similar language in state statute, and look where we ended up with the trailer park. And we're talking about, what, 400 spots? Who's to say it doesn't grow to 1,000? So if you don't draw the lines in the sand and make the perimeter of what everybody can do in a fair manner, and you just do it based on what's going right now, not what's potentially going to happen in the future, then you end up with a situation like we have at Ponderosa potentially down the road.
Rick Hostetler.
Well, I think you alluded to it so much, Ryan. There's a major difference. Those folks, they could be shut down at any time, and those folks can hook to their trailers or start their RVs and they can leave. That's not the case for the home park. That's not the case with the subdivision. But also, if you had a chance to read through some of the documentation on the Fuji system, there are small neighborhoods that are using it. And if I'm not mistaken, I think the state of Kentucky has already approved this type of system. I may be mistaken on that. I've been a little busy the last few days, but I'm trying to educate myself a little bit. The other thing is, going back to Chad's, I wish I had that paper in front of me, but when you get north of, I think it's north of the Mallard Point area, that line is at capacity from GMWSS on sewage treatment. But there are properties that are up there in that area of Scott County that I've had property owners talk to me about various things like an RV park. I don't know what size, but if they couldn't do it, and they have to tag on the sewer, and they're in that vicinity where the sewer's at, they can't get, there's no capacity. We're talking about tens of millions of dollars to improve that capacity, and how long that would take, well, I don't even think that GMWSS has come up with a number yet. I know they've been looking at that, studying that, because basically that Stateville area, as far as sewage capacity, is basically shut down. They're not accepting any more tie-ons, is the way I'm understanding it. Very, very limited. And so, but this Fuji clean system, it goes into tanks and it stays underground. It doesn't have any flow. As I shared with the court in our last meeting, I've worked on sewage treatment plants. There's always water, sewage coming in, and they say drinkable water going out into a creek or wherever there's a local body of water that it moves out of, and it's gone from that treatment plant and goes downstream where the stream goes. In fact, there are a lot of wet weather creeks that small communities put a sewage treatment plant aside, and they make it a year-long stream. It's always wet because it's treating sewage. And so, but there's always outflow. This is not the case from the way I understand that with this Fuji system. It's all underground, and it winds up out into lease lines. And if those things don't work, you just read it. There's things in place that, hey, the park has to close, the folks have to leave. But the way I understand it, there's nothing. I'm sure there's something that happen that's an environmental impact, but I can't find it in this information. So I think we got to be careful because it goes back to another point that was made last Friday. We're gonna demand that you have to tie the sewage. That will shut off a lot of people in the county from ever being able to develop their property into an RV park if they chose to. Thanks.
But Rick, the other thing is too, what I was just talking about, it also protects ratepayers on GMWSS, and it also protects taxpayers going forward. Because again, I'm not looking at the next 5 years. You know, I don't have any fear about that. What I have a fear of is 20 to 25 years from now, when you don't have the same ownership, you don't have the same people keeping up, no different than what happened at our trailer park.
David,
to Lexington.
Those people can't move, they can't pick up and move.
But if you-
The RV park,
but-
Judge just ready to be shut down.
But Rick,
They can,
but who pays the cleanup if something happened? Who pays to take care of that if something happens? I mean, again, $23 million has gone out the door to run a line to the trailer park when it should have been shut down in reality because it was polluting our aquifer. The other thing too is, yes, you can move it, but we're talking about, what we don't ever talk about is future development. We don't talk about future development enough. So you're talking about 400 spaces right now, but who's to say it doesn't grow to 1,000? And then 1,000 changes the game in what happens. With traffic flow, with sewer usage, with everything that goes on out there, it changes everything. And I'm not saying that these folks that would expand to that, but who knows if it happens 15 years from now? And you can't, it is hard to do a statute, an ordinance, with the influence from one group. Because that's what we're looking at right now is the development of one area right now, and we're writing an ordinance, and the input and and everything that's talked about and the feedback is coming from that group. Now, I'm not saying there's anything wrong with that, but it makes it difficult to clearly see what could happen in the future based on what we're getting from one source of information.
And, you know, the great thing about our court, the great thing about America is we can agree to disagree. We can take a vote and we can move on. I don't think we're all going to agree on this, and that's okay. It's okay. I've looked at what I see from the presentation, the science, and there is, to me, a difference. Do I have concerns down the road? Yes. But there's RV parks all across the United States that are generating opportunities, and I have concern about cutting that opportunity out because of negative issues in the past with a separate type of entity. You know, the folks at Georgetown Estates cannot pick up and move, but as the document shares, if testing's not done, if it, you know, as I read, it shall be shut down.
Who's paying for it though? I mean, what if we have a scenario to where there is an issue 15 years from now, it gets shut down, who does the cleanup? Because if they go bankrupt, guess who pays the cleanup?
And David, but that could go on a variety of things, and like.
And if you allow new package plant, the state of Kentucky is encouraging sewer tap on everywhere possible. If you start allowing package plants,
but this isn't a package plant.
It's similar. You could still have environmental issues with it.
Can I make a comment on that? Because what we're talking about right here, and this is going forward, it says RV campgrounds operating on a private sewer system must have a recorded agreement, etc. So while we may really like this sewer system in the future, we're going to have the same debate over other sewer systems. And I kind of go back to David, we know what we're getting when we do the public and how it's kept up. Somebody might want to open another park somewhere else on a cheaper sewer system that maybe not as good, but I bet there's not a company out there that's going to come and say, yeah, we've got a fail rate that's this high, or we're not a good product. Everything we're here is always going to be good, which is fine, but I would have concerns about the way this reads going forward. In my mind, it's probably smarter to have a public sewer system. That's my comment.
In the development plan process, any other development possibility would have to come before the planning commission, present, and that's the same thing with, you know, if you have a 100-acre parcel and you want to put an RV park in, then the development plan the ordinance has guidelines to fit, fit that parcel. And it all comes back to the planning commission. Like I said, it's okay if we don't agree. But
one question I have is, so there's an expense to this, the Fuji system. What's the expense to tie into? Is there a cost estimate has there ever anybody looked at what it would take if the owner provided that same amount of money that they're going to spend on the Fuji system to tie in with, to work with Georgetown Water to get tied in?
So,
In lieu of, what, I don't know if that's possible.
they can speak to it, but our Bluegrass RV experience has tried to hook the sewer to the city of Midway sewer, and they were denied that access. So
Right, capacity issue, I guess, with that one.
I'm not going to speak to the city of Midway.
Well,
I think there's legislation,
But
or
have we
there's
looked
a
at that in
lawsuit at this
Georgetown?
point, so I'm not going to speak to that.
I mean, it would be just
Way more expensive, I guess.
using our example in northern Scott County with the force main that's out of capacity. I mean, it would not make the business model work for a private
That's what I didn't
developer
know.
to have to pay for.
'Cause I don't know what the system is.
Yeah.
Do y'all know why it's out of capacity? Because we built it. We built it for leachate. We built it and paid for a package plant at Mallard Point. The taxpayers paid for all of that. Now we're in a situation, or ratepayers, now we're in a situation to where we're out of capacity because it promoted development. So guess what? The people who are already on the system are having to pay to upgrade that system, which will allow more development to outdate the system. So, I mean, it's a catch-22 where you run it, you start allowing things, and then someone comes and asks for more, and then someone comes and asks for more.
We're going down a rabbit hole. We're here talking about an RV text amendment. And whether you want to require that we have two drafts. And do you want to require that it's hooked up to sewer, or do you want to allow private providers? And that's really what we're at. And I think we've gone down into another area that's a different conversation, in my opinion. Is there any other comments from anyone on the court? And then I would allow Mr. Murphy to share comments, and then we can go from there.
Can we, to Kelly's point, and I think I asked this during our workshop, and maybe it's a question for Cam. It does say on a private sewer system. Can we make that a little bit more concise on what that means? Like, so it's not a package plant. Would a package plant be considered a private sewer system?
Yes.
So can we make it more concise so it's not as wide open? I
Last
don't know if
week
we
at the
can.
workshop, there was a name for the system that was shared. We could definitely consider that, yes.
I don't think you can do a name, but you could do a technology.
Well,
Scope or spec.
Yeah, yeah.
and Mr. Murphy, if you would like to address the
Can I
court.
make a comment?
Mr. Jones.
I think one of the things we're not doing is opening our mind to the technology that's coming out. As we evolve, technology is going to become even better with all these systems. Like this system they're proposing, if something happens, Stamping Ground has its own plant. There's no line run to Stamping Ground. They have their own plant down there. If something happened there, I think this system would work fine in Stamping Ground. I don't see no reason why it wouldn't. I mean, it's a pretty good system that they've come up with. They've proven that it's been in Japan for years, that Japan has used it. So I'm kind of on page with Rick and Ryan at this point.
Thank you, Mr. Jones. Mr. Hostetler.
Let me kind of dovetail with Rob there and go back to something that David said. And I get why he calls it what's called a package treatment plant. That's all we're used to. But, and the attorney there can correct me if I'm wrong, but I think they said basically everything to do with this type of system. I know this one's called Fuji brand, but they did give us another technical name for what it does. But it's all gravity flow. There's very little I don't know if there's any pumps involved, I can't remember what they said, but they do have fans for aeration, which helps in, dissemination of solids, but it's an enclosed system. And if you had to shut it down, it's just like in my house. I have a septic system, and occasionally it's 5 to 10 years apart. I have my septic tank pumped. That's what you do there, and that eliminates. You move the RVers out. If there's a real problem, which I really can't see, but if there is, you pump the tanks, and that's not going to cost millions. But that's just my thought.
Thank you, Rick.
Okay.
Anyone else from the court? And then Mr. Murphy, if you'd like to address the court.
Thank you, Judge. As you know, my name is Fiscal. I'm here on behalf of the Kentucky Bluegrass Experience Resort and two owners of that, Dennis Anderson and Andrew Colville, talk with me today, and John Strom, who's also an attorney with Anderson Community as well. We appreciate all the discussion, and we appreciate the kind comments about our proposal. I know you all have said, I think you're convinced about our proposal being able to work, and concerned about other proposals that might come up as well. I had emailed, that wasn't me. I emailed you all some data we had gotten after Friday, yesterday. And this is, I'm using, the name of this is the name that was used for the Department of Public Health. I put in there a letter where the Department of Public Health for the state has approved this type of system. It's called an advanced treatment system utilizing drip irrigation is what they have approved, this type of system. Now, in conversations with the people in the state, they've said, yes, we approve this system. It works. It's also now subject to the local health department approval for each and every particular installation. So the local department has to approve it. The state has to confirm that, yes, this is an approved system. The local department says, yes, it's approved here before we can get approved on it. And we gave you the list of Fuji systems and installations. They do. It's interesting, the more you learn about this system, they're working on 141 installations right now this year coming online, and they do 3,500 every year in the United States.
So the number's 3,000, how many?
500.
Installations?
Installations every year. Now, they do RV parks, they do subdivisions, they do commercial facilities. In Long Island, right now, most all new developments, I think, are required to have this Fuji system on Long Island, New York. They're very good in that area as well. But 3,500 a year. We don't know of any that have ever been shut down. We don't know of a single one that's ever been shut down using this system. Now, the question would be another system. We're not a package system, so if you want to exclude package systems, that is fine, because we are absolutely not a package system. And the thing to remember, too, we're a private system, but as Mr. Mike Dunn from Fuji Clean said last Friday, I think he said the number was what comes out at the end of our system is 8 times cleaner than what comes out of a municipal sewer system, whereas the municipal sewer system is much, much cleaner than a conventional septic system as well. So this is the cleanest part of the system. Now, what's the worst case scenario here? Let's say 30 years from now, we have a failure, or 30 years from now, somebody else who comes in using a different system has a failure. Well, under this ordinance, as Judge Covington read, if there's a problem, we have to shut down immediately. And just like we would be paying for our own system ourselves, we would pay for Fuji Clean or whatever the system is. It will not require a public bailout. either for to supply sewage to it, because as has been discussed, if we're shut down, it just says, okay, everybody, start your engines, drive on, and they're gone in a matter of a day. But what about, there's an environmental spill or something like that? I know you all are concerned about that. What happens if there's a spill that has to be cleaned up? Well, the state Environmental Protection Agency, by law, has a lien on that property to clean it up. If they have to clean it up, say the person becomes bankrupt and they have to clean it up, the state can come in and clean it up. If they've got a lien on the property, they can sell the property to get their money back. So
Would they be primary? Would they be the first lien holder?
I believe the statute says yes.
Okay.
Because the biggest fear mortgage lenders have is
Condemnation or whatever.
Condemnation
Yeah.
and lien holders too, because that can come in first and knock the private mortgage off the top rung of who gets paid on that. So there's not really a possibility of having to come in and making a private bailout of this. The concern we have is that we've got a system that is much cleaner than what can be done through a public system. And it's something that is affordable. Most places in the county, they couldn't afford to build public sewers. It's just shutting the door to that possibility to have to bring public sewers in and serve that area. Just wouldn't work. Just made some notes coming through. I want to make sure I covered everything. As far as this being written for us, it wasn't written for us. We reacted. The planning staff had written up an RV ordinance. We saw that and then started to participate. We didn't write this. We weren't standing over anybody's shoulder while it was being written. We got the draft and then we gave our input to the planning commission, who made some minor modifications on it. But we weren't the ones drafting this or pushing it. So the long and the short of it is we're asking for the opportunity. We have a long road in front of us before this can start. Even if you pass the ordinance, obviously we'd like you to pass the ordinance which does not require a public sewer fee to it. But if you pass that ordinance, we still have a long road. We've got to plan this. We've got to go through the zoning process to the planning commission and to you. We've got to do a development plan that's going to be signed off by planning commission, fire department, and all the other people. So you're not saying by taking your action today or when you take a second reading on it, you're not saying, okay, go and do it. All you're saying is, we're going to give you the opportunity to do this. We're not going to close the door on it. We're going to open the door and be able to go through those steps and proceed to do it. I think Dennis probably wants to say something that's all along the line.
Joe, can I?
Yeah.
Real quick.
David.
This is, I was not inferring that you all had input on writing it to your design. What I'm saying is, you're the ones in front of us who have the opportunity at this point, and this is, we're designing this ordinance, or this ordinance for that, and you're, fortunately or unfortunately, you're the only ones in front of us at this time that could have this opportunity to provide the information. The other thing is too, I'm not talking about your development. I'm talking about what does this open the door to in other developments due to the fact of what we've seen things happen, of decisions made 20 years ago that the county, the city, and GMWSS have now had to spend millions upon millions of rate dollars and taxpayer dollars. So this is not a reflection on you all at all. This is passing the ordinance. What does it open the door to going forward? No different than I've used the example on 25 3 times now. there was an ordinance passed or a zone change passed that allows something that was never the intent to be able to be put in the greenbelt between Fayette County line and Georgetown. But the way that it was passed, it opened up that door. And in 5 years, 10 years, 20 years, that could happen, which is a concern of mine because that was never the intent of why that greenbelt was put in place. We don't want to be Nicholasville and Lexington. You leave one and you can't tell where you're going to the other. So I'm comfortable with what technology you're putting in, but it's about how do we make sure we do this correctly when it just says private sewer. Well, who knows what comes out? But how do we change it correctly so that we're not inhibiting an opportunity for someone else that also has good technology in the future?
Well, I think one thing you can remove package plans from the possibility as well. I think the ordinance has been narrowly drawn so that you are prohibiting those future expenditures of tax funds to bail people out. And part of it's just because of the nature of an RV park. But part of it too is because there's good systems. It has to be a state-approved system first. It's a good system which has a great track record. But if it malfunctions, and I know you all have to think about that, your ordinance, I think, has set the parameters that there will be no expense to the public, no taxpayer expense at all, if there is a failure, which has to be cured.
David, you mentioned something about,
Mr. Anderson.
Steve, appreciate you doing all this with us. But I just checked with Joe Kane today. He did the RV park areas of the Board of Adjustment. It wouldn't even come to you. But this text amendment, it comes to you. It gives you more control.
I had a comment. Mr. Jones?
you mentioned developments. Are you talking about like housing developments also, or just these?
What do you mean?
When you said something.
I don't know. I mean, that's.
This is RV only.
Right.
So
But
it
what's
doesn't
to say?
incorporate to subdivision, right?
I believe, Joe, and you can correct me if wrong, that you are now, it's the way the ordinance is read, you can make subdivisions on these plants, right?
No,
Oh, you
no,
can't?
no, you
I
can't.
thought there was one approved at one
No,
point.
well, you could, but you still have to maintain the current 5-acre density. So
Okay.
this would not apply to rural residential.
It wouldn't be.
Density, so that policy would still be in place. And there was, right now, as Mr. Anderson said, RV parks are conditional uses, so they would just go, if an RV park came in today, want to apply, they would just go to Board of Adjustment for approval of the use, and this system could be used today, under our current guidance, if it's state approved and if it goes through the health department. There was an RV park approved in 2008 on the Bevins property where that zone change occurred, so it was a KOA campground. I think it had 300 RV parks. It was going to be on a package treatment or on a shared septic system. So, I mean, this has occurred in the past through the Board of Adjustment. So this would give.
About right here on 25?
Yeah, 25, Bevins property. That whole property was approved for a KOA campground right before the WEG games, 2010.
That was before I was
Was that
here.
5 acres, or was that on the 5-acre?
It was a maybe an 80 acre site. I
That's
think.
right, because it butts up to the Pratt's.
Yeah, I don't remember how many units. I think there were about 300 RV sites on roughly 80 acres.
Okay.
It was approved, but they never moved forward. It never, everybody was trying to get everything approved prior to the WEG games, and they never kind of took them. They never got it going fast enough, so it just dropped.
So, any other questions or comments?
I'm generally for this option one that was sent out. We sent out 2 options, but like we talked about, I would like to see, instead of private sewer system, something more concise, so we don't get package plants or septic or some, I don't know what the language can say.
My question is, how do you draft that? Because I'm looking up.
RV campground operating on private sewer system, excluding private package treatment plants.
Then you'd have to define package treatment plants, and why is this not one, and why is something else one?
Maybe we can get some language from the state on what their standards
the
are.
EPA, just from a quick Google, says packaged plants are pre-manufactured treatment facilities used to treat wastewater in small communities or on individual properties. So how do you say what is one and what isn't one? That's trickier than it sounds, I think.
Right.
Do you want to say must use a private system using drip irrigation technology?
Is there a way to have,
Let me ask you, is there more than one company that does drip irrigation
I'm sure,
technology?
yeah. Is there a way of a review of each system, but then it becomes
Didn't the guy from Fuji Clean last week, he gave it like a scientific name, like an osmosis.
I think
I'm
I
making
said
this
that.
up.
I think I said that.
You said that?
Yeah, because I was thinking like water treatment in general, like my
Process of studying in college.
I was just making stuff up. I think.
Quit
you heard me.
saying stuff out loud. But that guy, he also said something. He said it was called something.
Yeah, I mean,
And
it's-
I can't remember the name of it, but the general system. Maybe we could find out the name for this general type of system and add that general type of system in.
I'll be honest
Or
with you.
I guess you could also have the end result is the water that comes out, what it tests at. You could use that as somehow, some sort of standard some sort of system that meets that standard of clean water at the end. I don't know if multiple ones can meet that, right?
If you look at what the Hamlin Health and Family Services said, they refer to it as an advanced treatment unit.
Which is bogus.
I'm just using that's their version. Judge, before I think we're at the point we need to do something. I need to ask a clarifying question. We tabled this discussion a couple of meetings ago. So do we need to make a motion to bring the discussion off the table? And, what's the, Cam, I'll refer to you, or this is the first reading of an ordinance.
I mean, it's the first reading of an ordinance, but honestly, I still don't know which way y'all want to go, which is fine. It seems pretty split. There's two main issues, right? The one issue is the public versus private sewer. The one we haven't even talked about is the 200 versus 400 threshold. So I guess you could take it off the table, but I guess maybe vote individually on those two issues maybe, and then we know which one we're even considering.
Can I give my thought?
You may.
Absolutely.
Can't believe you would.
Yeah, I can't wait.
No, I prefer the text amendment with a secondary emergency access entrance, which may be gated on the 200, not dual public entrances, but a gated entrance that.
It doesn't matter.
Yeah.
Anything over 200 has a gated emergency access entrance. Is that what you're saying?
Yes.
And it doesn't matter after that.
And then once it gets to 400, that has to be opened, right?
Once it gets
Has,
to
has to be another
no.
entrance, right?
Once it gets to 400,
Yeah, that's under the current.
well, what I'm saying is I don't care as long as once you go over 200. But my question is John Ward good with once it goes over 200 having that secondary emergency access? Are you good with that for life safety and protection of
Knox box or something like that, access.
and then yeah, and
Yes.
I think then it doesn't matter if you go over 400.
If you go over
got-
4, it requires a secondary public, and then if you go over 6, it requires a third connection.
That's what it
Public
says.
connection, yeah.
If that's what you all want.
Okay.
But the only thing that changed in that section A is where with more than 200 to have a secondary access for emergency.
I have a question though. Do we need that language
Version 1 and version 2.
if in the new one Cam added in the I that says that the recreational RV campground shall be designed to minimize congestion and hazard at each entrance or exit and allow free movement of traffic in adjacent streets. Like he added that in. So do we need more entrances
That
if
was
that's in
language
there?
suggested by Joe Kane to address the concerns that Mr. Livingston had brought up.
Because like, isn't that the point of the two entrances, to decrease congestion on the streets? So would that be necessary if we have that other language in there?
It's probably a question for Chief. He's saying if we have a wider entrance, do you need a secondary emergency access?
No, I'm not talking about emergency. I'm talking about public access after the 400.
Oh, I got you.
I'm just talking about the public access. Do we need more public access if we're decreasing congestion, if it says that they can't congest the streets?
Well, I would suggest leaving that language that we added, just so it gives us guidance in reviewing the development plan, so we make sure that they have sufficient stacking and parking.
Yeah, no,
at
I'm
the
fine with
entrances.
that, but do you think that we still need, so if it gets over 400, do they need a second public entrance if we have that language in there, is my question.
Yeah, yes, I would say that's what the planning commission recommended. That's what kind of we thought was a
Okay,
good threshold.
I'm fine with that. I just wanted to make sure.
I
If
would
it
say
goes
yes,
over
it's-
400, having a second public entrance.
Yeah, that was the planning commission recommendation. I think it's fair.
But what John feels like, if it goes over 200, we need a locked emergency access. All right.
So it sounds like we have some consensus on that.
So,
Maybe. Not everyone's spoken.
so back to, the verbiage on anything regarding a RV campground operating on a private sewer system.
Hey, Judge, I've got a suggestion on what you're talking about there. And Mr. Murphy or Mr. Anderson, they're more familiar with that Fuji system or that Fuji type system, but I don't think it's surface. So if you're talking about a package plant, I guess we could write it up. A package plant is going to have an inflow and an outflow that's on top of the ground. This Fuji type system is totally contained. It doesn't resurface after someone washes their hands and it goes down their sink in their RV and winds up in these tanks. If I'm correct on that is a huge difference, and we ought to be able to write that up.
So are you suggesting that the verbiage should be RV campground operating on a private sewer system must be contained?
Is that correct about that type of system? I think I'm correct.
Well, aren't we, Rick? I mean, I know you and I deal with this type of stuff, but we still, as much as we deal with it, we're not experts about what it should say. So shouldn't we lean on the people at the state, the people that deal with sewer and stuff, to give us some language about what kind of wordage? I mean, you and I mean, we shouldn't be making this legal language up that's on a spec or a scope. That should be the people, architects, engineers, somebody like that needs to be giving us this language.
Sure.
So are you asking Dwayne that we get clarification on verbiage to identify
The appropriate,
that would prohibit
right.
prohibit
what we don't want.
a package treatment plant, but encourage a closed drip irrigation system
That meets a high standard that we expect.
So, as much as I hate this, gosh,
Read it with, that letter, pending that clarification of letter.
I just want to make sure
I
this
would
also
table it
wouldn't
just 'cause that's a
include
pretty-
septic, right?
yeah,
That's a pretty,
pardon?
This also would include septic.
important provision.
Could you do septic on that?
No, you wouldn't have the capacity, right?
No.
No way.
So, in fear of like having a first reading and then having to start
Redo it.
over,
Yeah.
let's. I think we're all in agreement. Anything over 400 requires a second entrance, is what I'm hearing. My biggest concern was anything over 200 having emergency access. We must have that, but then you know, if we're gonna vote for, if there's gonna be a motion for a private sewer system, then we want the verbiage that prohibits an open system like a package treatment plant, but encourages a drip irrigation closed system to be put into practice. So we'll come back.
I'm sorry to interrupt you. Mr. Murphy, if you have like suggested language, I'm happy to, you email me or something. I'm happy to listen. Sorry to go back.
Yeah. But,
Hey, Judge?
yes, sir.
It sounds like we're gonna table again. So one other question, totally different from what we've been talking about, and I don't know what item it is. But it says, one of the points says maximum density of 10 RV sites per acre when served by public sanitary sewer, and a maximum of 5 sites per acre when served by private sewer systems. I actually don't know. The RV park I'm most familiar with is the one that's in the district that I serve, and I've been in it many times, and they're a lot denser than that, and I'm pretty sure they're on the sewer system.
They are.
I'm just saying, what difference would that make? Because if we go with this other type of system, they would have to design it for 5, 10, whatever, or does that, I don't know what that number means, I can't, you know what I'm saying? On that part of it.
It was just, and I'll let Joe speak to it. I mean, if you want to speak to it, Joe, but it's a number that they felt like they could work with on a density level that would you know, give, you know, it's not as dense if it's not on sewer. If you're on sewer, you can be more dense. Is that right?
Right, and, yeah, well, that's kind of the way I'm understanding it, but my point is, if this Fuji type system works like I'm pretty confident it does, I mean, you got a whole country that's using it, and all over the United States, these things are going in and they're working, that actually, you know, that's just a design issue. I'm just trying to think outside the box. I'm trying to limit the property owner, I'm trying not to limit the property owner and the developer no more than we have to. It's reasonable to make sure we're taking care of services and public. That's all I'm thinking about. If you can do it with public sanitary sewer, in my view, this type of, the Fuji type of system actually is going to take the pressure off the sanitary sewer system. And that's it. That's my last question. Thanks.
I'll just address where the 10 per acre came from. I think the state requires each RV site to be a minimum 3,000 square feet. An acre is 45,360 square feet. If you take out the roads, you know, access roads, you can the maximum amount you could get is basically 10 RV spots per acre. We were thinking for small sites in urban areas, we would allow basically up to the max that you could possibly get in those areas, because they'd be, you know, smaller.
Because to be served by sewer,
parcels,
right?
and they'd be served by sewer. The 5 we just split that in half because these are rural areas and you're gonna need open space. There's gonna be recreational stuff going on. So we basically just split that in half for these rural areas so they wouldn't max out the sites in these rural areas.
Okay.
That's where they came from.
Thank you.
All right. With that said, then we'll try to get some language and bring this back for a vote at our next meeting.
Can we put language in there that they have to run a shuttle to the downtown businesses in Georgetown?
I'm going to move to number 11. Lease agreement, Shelby Broadband. It was presented to you. $125 per tower for both towers, 3-year agreement. That's pretty much cutting to the chase. Any questions or comments? That was shared by email.
I didn't get it.
It was from a while back.
Yeah.
Judge, just to get cheap internet for other places, I'll make a motion that we.
All that's doing is not excluding anyone that's currently currently on service.
Broadband.
So we have a motion, we have a second. All right. For the record, though, I think Rob beat you. So we have a motion, we have a second. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Now, we have three resolutions, 2321, 2322, and 2323 for CDBG, Amen House. This is a gift that keeps on giving. I've read this several times, and I'm going to ask Cam to read these, and I'm going to excuse myself for just 1 second.
Scott County Fiscal Court, Scott County, Kentucky, Resolution 2321. A resolution for the Scott County Fiscal Court to approve the grievance procedures for complaints relating to suspected allegations of discrimination on the basis of handicap status in Scott County, Kentucky. Whereas the Scott County Fiscal Court County has been awarded funding for a community development block grant for CDBG for the Amen House Food Distribution Center Community Development Block Grant, CDBG number 22-25. And whereas as the recipient of CDBG funds, the county is required to comply with Section 504 of the Rehabilitation Act of 1973, 24 CFR Part 8. Now therefore be it resolved by the Scott County Fiscal Court to undertake the following. 1. Any person, employee, or citizen who believes that he or she has been subjected to discrimination as prohibited by Section 504 of the Rehabilitation Act of 1973 and pursuant to regulations of 24 CFR Part 8, published in the Federal Register on June 2nd, 1988, may personally or by a representative file a complaint with the Judge Executive, Scott County, Kentucky. A person who has not personally been subjected to discrimination may also file a complaint. And 2, when any person, employee, citizen, or applicant who believes he or she has been adversely affected by an act or decision by the Scott County Fiscal Court, Kentucky, and that such act or decision was based on handicap status, he or she will have the right to process a complaint or grievance in accordance with the following procedures. A. Step 1. An aggrieved person must submit a written statement to the Judge Executive setting forth the nature of the discrimination alleged and facts upon which the allegation is based. B. Step 2. The Judge Executive shall contact the complainant no later than 15 days after receiving the written statement to establish an informal meeting with the objective of resolving the matter informally. However, in no case shall the informal meeting be conducted sooner than 5 days, nor more than 45 days after receiving the written statement. There shall be prepared a written documentary of the discussions at the informal meeting, which shall be preserved in the records of the Scott County Fiscal Court, Kentucky. Step 3, within 15 days of the informal meeting, if no discussion has been made by the Judge Executive or no decision has been made by the Judge Executive, or the decision of the Judge Executive does not satisfy the complainant, he or she may request a hearing with the Scott County Fiscal Court by submitting a written request to the Judge Executive. C. Step 4. In thus discussing the grievance, the complainant may designate any person of his or her choice to appear with him or her and participate in the discussion. The Scott County Fiscal Court shall require the Judge Executive to participate in the discussion of the grievance when it is brought before the Fiscal Court. The Scott County Fiscal Court shall issue a written decision on the matter within 15 days, and the decision shall be the final procedure for the complainant at the local level. There shall be prepared a written document of the discussion at the hearing, which shall be preserved in the records of the Scott County Fiscal Court, Kentucky. Be it further resolved that the Scott County Fiscal Court does hereby approve this resolution and authorizes the Judge Executive to execute same on behalf of the county.
Questions or comments? Motion from Mr. Livingston. Second from, is that you, Mr. Wallace?
Yes, sir.
Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes.
Next, Scott County Fiscal Court, Scott County, Kentucky, Resolution 2322. A resolution of the Scott County Fiscal Court relating to certification of a drug-free workplace policy for county employees and officials. Whereas it is necessary under the regulations as promulgated by the Commonwealth of Kentucky that the Scott County Fiscal Court approve the certification of a drug-free workplace policy for county employees and officials for undertaking the Amen House Food Distribution Center Community Development Block Grant, CDBG number 2225. Now therefore be it resolved this 8th day of September 2023 by the Scott County Fiscal Court that one policy, employees are not to unlawfully manufacture, distribute, dispense, have possession of, use illegal drugs or alcohol on the job, or report to work under the influence of illegal drugs or alcohol. Employees are not to report to work under the influence of illegal drugs or medications that might impair job performance without notifying their respective supervisor. It is the county's intent to maintain a drug-free workplace so that all employees have a safe and productive work environment. Any employee violating this policy will be disciplined according to existing or subsequent statutes or personnel policies. 2. Procedures. A. The above policy statement will be distributed to all county employees. They must provide written acknowledgement of receipt. In addition, the county will distribute and maintain posters indicating the county's drug-free workplace policy throughout all county departments and offices. The county will conduct a drug and alcohol awareness program on a periodic basis. B. All employees are to notify their supervisor or department head of any drug convictions within 5 working days after the conviction. Failure of any employees to notify their supervisor or department head of such convictions is cause for disciplinary action. Notification of such convictions are to be immediately communicated by supervisors and department heads to the Scott County Judge Executive. C. All supervisors or department heads are responsible for enforcing this policy. If sufficient cause exists to suspect an employee of violating this policy, the supervisor or department head is to report such conduct to the Scott County Judge Executive. Once reported to the Scott County Judge Executive, arrangements will be made for appropriate testing by competent medical authorities. Failure to participate in the prescribed drug testing and or evidence of behavior contrary to this policy are causes for disciplinary action under existing or subsequent state statutes or county personnel policies. D. Employees reporting to work on medication prescribed by physician which might impair job performance are to immediately notify their respective supervisors and or department heads of such. The employees shall indicate via a doctor's note how the medication will affect the job performance. Appropriate steps should be taken by supervisors to alleviate any hazards that might result from an employee working while taking such medication. Be it further resolved that the Scott County Fiscal Court does hereby approve this resolution and authorizes the Judge Executive to execute same on behalf of the county.
Motion, second, Mr. Corman. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Just want the record reflect Mr. Hostetler had to step out of the meeting. And then last.
Last and shortest, Scott County Fiscal Court, Scott County, Kentucky, Resolution 2323. A resolution for the Scott County Fiscal Court to bear any cost overruns on the Amen House Food Distribution Center CDBG project, CDBG number 2225. Whereas it is deemed to be in the public interest that the Scott County Fiscal Court is currently involved in securing Community Development Block Grant or CDBG funds for the Amen House Food Distribution Center Community Development Block Grant, CDBG number 2225. Whereas the Scott County Fiscal Court is mindful that the cost of the project may be greater than the amount of any Community Development Block Grant funding, and whereas it is necessary for the Scott County Fiscal Court recipient will enter into a legally binding agreement with Amen House Incorporated nonprofit, in which the nonprofit agrees to absorb all additional costs for the above referenced project. Now therefore, be it resolved that the Scott County Fiscal Court does hereby approve this resolution and authorizes the Judge Executive to execute same on behalf of the county.
Motion from Mr. Jones, second from Mr. Pratt. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. Fire Department surplus, there was an adjustment. I'm going to ask Mr. Chief Ward to speak to that.
Yeah, we found out after I'd already submitted this that Stamping Ground Fire is interested in a plymo vent system that we have at the Sadieville location that we're taking down. So that would be the change, is still surplus all the equipment, donate the plymo vent system to Stamping Ground Fire, and then the aeration system to Harrison County Fire Department.
Question? Motion from Mr. Livingston, second from Mr. Jones. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. Fire Department position. Chief Ward and Jeff, would you all like to speak to that, please?
Yes. Sure, I'll start with a few brief comments. I already sent you an email which covers John Ward's desire to create a full-time admin assistant clerical type position. As you know, he has had a person working on a part-time basis for quite some time, and what he also has is funding for an additional part-time position. He desires the opportunity to combine the funds of those two part-time jobs into a full-time job. I gave you some information here just on what the cost would be to do that. It's about $8,000 more in wages probably if you combine the two, and then there would be a benefit cost with that position too. So the benefit cost could be as much as $26,000, but if the person selected doesn't elect the health insurance, then the cost would be about $13,000. And based on my discussion with Michelle, there is funding available in the budget to cover this expense. So I gave you a copy of the position description, and I think what Chief Ward is desiring to do is just to balance the workload that he has in the department and get the right people doing the right work. So what questions do you have? And either John or I can answer what questions you might have.
What's the range, the pay range?
Probably in the $19 to $23 an hour range. I think the cost on an annual basis would be around $40,000 just in wages.
We vetted this out in Finance Committee multiple years, and we budgeted for it this year. So I'll make a motion for approval.
Motion. Second from Mr. Livingston. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes.
Is the person taking the position associated with this motion?
Well, all this is establishing the position.
Okay.
We'll advertise the position and then go through the process. Thank you all.
Thank you.
Judge Magistrates, I just want to say thank you all. The position is very much needed, and I appreciate you all's support. One thing I do want to bring up for the parade tonight, we will have a truck in it, so everyone's welcome.
Rescue One.
Rescue One, yeah.
Where's the
Military
staging
Street.
area?
I think out on Military College area. Ready.
Yep.
Yeah. So we'll
Bring
be
your own
there,
candy.
so everybody's welcome to come out.
All right.
Thank you all.
Human Resources, new hire intern.
Yes, I'm pleased to recommend the appointment of Eli Gilbert as the HR intern for this. It'll just be for this term. He can begin work on September 18th, and of course the pay for an internship is $10 an hour. I indicated what his degree was in, and he's also going into his junior year. He's considering another internship. I hope he chooses us over that opportunity, but I'm presenting him now with the anticipation he'll accept this position with us.
Motion for Mr. Livingston, second for Mr. Jones. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes.
Thank you.
We
Oh, and I
need
don't, yeah, we're going to skip.
Skip 18, skip 19.
That's correct, yes.
We'll come back to those. Number 20, as discussed, and in some other conversation with Magistrate Chad Wallace, it was suggested that in consideration of abandoning, the discussion that we had about abandoning the right-of-way at the end of Pinehurst Drive, that all this body can do is simply vote to abandon that. Then for the plat to be recorded, the property owner would have to hire a surveyor and have that plat recorded. So just wanted to make sure that was clear with everyone. Questions or comments, and it'd be my recommendation. And I just want to remind you, I've spoken with Superintendent Billy Parker, talked to Dwayne as well previously. Never does anyone think that it would be a good idea to have that open, even as a walking path. Or especially a motor vehicle path. So with that said, would anyone consider making a motion to abandon that right of way? I have a motion, second from Mr. Wallace. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. Resolution 2324, financial policy. Michelle, we have discussed this at length on many occasions, and it's I think it's the appropriate thing to do. It gives us, just gives us some structure. Cam has a resolution summary there. I'd like to ask if there's no questions before reading this, I ask Cam to go ahead and read it.
Scott County Fiscal Court, Resolution number 23-24, a resolution of the Scott County Fiscal Court, Scott County, adopting a fund balance, debt management, and investment policy, or policy. Whereas Scott County deems it appropriate and necessary to establish fund balance, debt management, and investment guidelines for Scott County by adopting a policy, and whereas the policy ensures that Scott County maintains adequate fund balances in order to achieve the goals of providing sufficient cash flow for daily financial needs, securing and maintaining investment-grade bond ratings, offsetting significant economic downturns or revenue shortfalls, and providing funds for unforeseen expenditures related to emergencies. And whereas the policy establishes a set of parameters by which debt obligations will be undertaken by Scott County, reinforcing the commitment of Scott County to manage its financial affairs so as to minimize risk, avoid conflicts of interest, and ensure transparency while meeting capital needs. And whereas the policy establishes sound investment objectives that meet the financial goals of Scott County. Now therefore be it resolved this 8th day of September 2023 by Scott County, Kentucky. Scott County, Kentucky Fund Balance, Debt Management, and Investment Policy is attached hereto and incorporated by reference as if fully set forth herein in its entirety, is hereby approved and adopted by the Scott County Fiscal Court, done this 8th day of September 2023.
Questions or comments? Motion. A motion from Mr. Pratt and a second from Mr. Corman. Any other questions or comments? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Thank you all. We are now going to go to number 22, grant application cybersecurity, and we're going to swing for the fence. I think it's wise to do this. I think that it's only going to come back on the plus side for us. I am asking you to approve application for the cybersecurity grant in the amount of $415,67. 20% match would be committed in the amount of $83,014. We're going to be applying for a variety of threat protection, things to be put in place: endpoint detection response, email security, phishing protection, security awareness and phishing training quarterly, multi-factor authentication management, website filtering, ransomware file restoration, the onboarding of all this, firewall management, advanced penetration testing, ransomware attack simulation, cybersecurity consulting, and then asset management. We're also applying for approximately $192,000 worth of services with our data backup agreement with Madison County, Kentucky, through the Madison County Data Center. And then we're also applying for wages and benefits for our IT consultant as well, or IT coordinator. It also has about $10,000 worth of hardware purchases for firewalls at the road department, I believe, or extreme switches. So this is a very comprehensive approach, and I'd be happy to try to answer any questions. If Chip has hit the ground running, if we can bingo on this, it'll be awesome. But if you have any questions.
Are all of our systems on one server now, or do we still have systems that are on an island in different departments?
They've not all been moved over yet.
But-
That's still in the process.
Okay.
But this would get us all virtualized and all moved to the Madison County Data Center.
Okay.
I would say that on a serious note, when we were in Louisville at the training, we did watch a cybersecurity presentation. There was a Fiscal, I can't remember where they were from, but they got hit and had to pay They asked for 500,000 in Bitcoin, and they got it negotiated down to 50,000, and so it happens to fiscal court. So I'm all for it. So.
I don't know if you know this, Morehead State got hit. Chip, are you aware of Morehead State getting hit? I think it's Morehead State. It's one of the state universities, and I believe they are still down in part of their systems because of it.
So was that a motion from
A
Mr.
motion.
Pratt?
Motion.
Second from Mr. Livingston. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. SRO agreement. Mr. Wallace has a comment related to what was presented by email. And I agree with Mr. Wallace. The judge executive, if there's an issue at the school level, Mr. Wallace, would you like to spell that out?
I'm trying to bring it up, but I believe it's in section 5. Basically, if there's an issue between the SRO and the principal will report page 12 to the superintendent, and the superintendent has 5 days to respond, and then they would reach out to the judge executive. And I felt like the sheriff also needed to be included in that agreement as well.
You put and sheriff.
Yes, that's what, and I think that would happen, but I just want to make sure that's written there. That's the only issue that I had.
Any other questions or comments? Would there be a motion to accept as amended? Motion from Mr. Livingston, second from Mr. Wallace. Any other questions or comments? All those in favor, please say aye. Aye. Any opposed? Motion passes. I do want to mention that I've been working to try to get a contract price for the EMS construction costs. And yesterday we thought we had it, but doing the value engineering, some of the items that were given to us were estimates, and one was an estimate on the apparatus bay deletion. Well, instead of about $425,000, it came back at $190. Instead of the deleting the rear access road being, I think it was $250, it came back actually at $220. So I went to Mike Carroll and said, Mike, we got to cut some more items, and we cut some more, and we've gotten the items down to about $7.1 million, but the item that's keeping us from being able to actually have a contract is when we did the value engineering, the low bidder recommended changing possible mechanical subcontractors, and that would change who does the geothermal. Well, he's trying to get the cost of the geothermal from the second subcontractor, so we have to wait. So I've talked to RJ today, Palmer. He says if we have to wait another 2 weeks, it's not an issue to them on the bond. So hopefully we can get all this on paper, lay it all out, so everybody knows where we're at. And really and truthfully, what we're looking at, if we want to keep about $25 million in our reserve, we're looking at probably bonding more like $11 million. But we'll get that, and probably be a 12-year term. That would keep us around about $1 million payment. Yes, sir.
When we make those decisions on the bonding and stuff, is that, since it is EMS and they're local, how does that work together with our partners with the city?
The bonding is for us alone.
Right, but I mean, have they voted?
So once I get a contract price,
okay,
then I will ask you all to approve, contingent upon city council approving that contract as well. I think that's just the right thing to do. And Devin and Mayor Jenkins, Devin Golden, Mayor Jenkins, I've been in conversation with them, and they have this information as well, and they understand that we're waiting on just that mechanical question. trying to do the value engineering and save some more money. So I don't have any other new business other than I'd like to ask you to consider a hand check for postage for the clerk's office for the Pitney Bowes machine in the amount of $10,000. It came up yesterday and it needs to be addressed.
Motion for approval.
All right, motion. Would there be a second? Second. Any other question or comment? All those in favor, please say aye.
Aye.
Any opposed? Motion passes. We need to go into executive session for KRS 618101C.
I got one other piece of new business, if I can remember,
all
we
right.
talked about, just briefly. I just got some positive news to share, or one item to share with you at least. I was selected to participate in Leadership of Scott County for the year 23-24 year. Also joining me is Tom Ramsey and Shelby Lyons, who are also classmates for this year. And I know several of the people in this room have also participated in Leadership of Scott County. And if you've done that, you know that one of the things you have to do is select a project for the year. And after looking at about 15 or 20 different ideas, the class has narrowed it down to a beautification project at Great Crossing Park. And what we would like to do is to put in trees along the walking trail. Right now there's not any trees at all along that walking trail, and it would be a beautification project for that. Looking at about 15 trees along the trail and some ornamentals at the beginning and end at both ends of the trail, and then in some benches along that trail too. The committee plans to, or the class plans to present this to the Leadership Scott County Board on Wednesday. And the reason why I wanted to get in front of you is to make sure there weren't any objections or concerns about this project. There won't be any impact on the county. The only thing we would need county help with, and JR's already agreed to this, is just augering the holes for planting the trees would just make things a lot easier than having to dig the holes ourselves. So all the planning, mulching, all that kind of stuff would be done at no cost to the county. So just wanted to share that with you.
Digging with the shovel like a rite of passage, though?
Well,
I think we had some shovels.
It has to do
with
with you all discussed improvement in technologies earlier today, so that's an improvement in technology.
If you could share when you'll be digging those holes, using a rock bar out.
We could send the kids over from Great Crossing over that.
Yeah, and if football season's still going on, we could get the football players to help.
Don't forget to call 811
Jeff,
before you dig. It's
in
the
a
law.
serious question,
Yeah.
what kind of tree are you going to put down there? You're not.
We're looking at
putting
maples.
pears or- huh?
Maples.
Okay.
Something hardy that
All right.
that has good color in the fall too. So.
Yeah, thank y'all for choosing that too, because I've had people ask about trees along the walkway down there, so I appreciate y'all doing that.
Fantastic and much appreciated. Thank you very much.
All right. Thank you.
Thank you. Are you ready?
Yeah. Is there a motion to go into executive session?
Yeah. What do we need to go under?
618101C, pending litigation.
Okay, pending litigation. So motion for approval to go in executive session.
Second.
For pending
Second.
litigation.
Any other comments? All those in favor?
Aye.
Any opposed? We'll go into executive session. Would there be a motion to come out of executive session? We have a motion, we have a second. Any questions? All those in favor, please say aye. Aye. Any opposed? We are out of executive session and there was no action taken. Is there a motion to adjourn this meeting? Motion. Is there a second? Second from Mr. Corman. All those in favor, please say aye. Aye. We are adjourned.